Good morning, everyone, and welcome to our 98th episode for AAA Weekly Webinar Series. Today, we are discussing a very, very important judgment from the Supreme Court of India with respect to the rights of the landowner in the case of real estate matter. This is a Greater Noida matter, and a lot of takeaways from this judgment. So, over to Anil, sir.
Thank you, Ankit. See, we are again very happy to reach to 98th episode of AAA Weekly Webinar Series. Very soon to reach 100th webinar. And we have decided that the 100th webinar would be in the physical form and as well as the digital form. So it will be a hybrid format, and we will try to have a kind of panel discussion that day with some of the dignitaries that will come on this physical 100th episode, and it will be followed by celebration dinner. So that will be on 10th March. Instead of Saturday, it will be on Sunday evening, because the Sunday evening we find that the people may be able to reach. So this is also can be considered as an information to all of you that the 100th webinar will not be on Saturday. It will be on Sunday in hybrid mode, and anyone who has the invitation for physical presence, that will be followed by celebration dinner. Coming to the subject today, this in fact this judgment came last on 12th of February, and we in fact planned that we will deliberate on this judgment in the last Saturday. However, the urgent issue was to deliberate on various regulations released by IBBI. So we did that. So in fact, a lot of changes have taken place in IBBI regulations for liquidation as well as for CIRP. And before that, in fact, 5 other regulations were also released. So now this judgment, which is the citation is Greater Noida Industrial Development Authority versus PRABHJIT Singh SONI, and this is from Honorable Supreme Court, and it is a 3-member bench released on 12th of February 2024. And see, like it's like by Honorable Chief Justice of India, Dr. Justice Dhananjay Chandrachud, then Honorable Justice J.B. Pardiwala, and Honorable Justice Manoj Mishra. These like one of the very, very important judgment for the real estate industry. My understanding is that this particular judgment will also have impact on various other like CIRP cases. The issues, 2 issues which are in fact very, very important, whether the under the IBC, whether there is any power with the adjudicating authority to recall an order of approval passed under Section 31, subsection 1. That means Section 31, subsection 1 deals with the approval of resolution plan. So the Supreme Court analyzed the issue, powers under Section 60, subsection 5 of the IBC code, and then decided that the adjudicating authority has the power to recall its order where the resolution plan has been approved under Section 31, subsection 1 of the IBC. Now, the second thing which was decided by this judgment, whether the application for recall was barred by time. So this is based on facts of this case. It is not the Honorable Supreme Court said that looking into the facts and the dates, this application by Greater Noida Industrial Development Authority, which now we will call GNIDA, this application by GNIDA was not barred by time. So this particular part is based on the facts. And the other part is whether the any resolution plan which is not meeting the requirements of section 30 subsection 2 and regulation 37 and 38 of CIRP regulations, whether that resolution plan can be put forth and can it be a valid resolution plan approval. And the other, which is very important, is the in a resolution plan, if a particular appellant, if a particular claim is not even acknowledged and not even admitted, whether that resolution plan can be considered as meeting all the requirements of section 30 subsection 2 and regulation 37, 38. And of course, the other issue, which is like GNIDA, which was the applicant in this case, and they are also the owners of the land, and the land was given on lease to this real estate project. They have, whether they have a statutory charge over the assets of the corporate debtor, and in case they have, then they should have been considered as the secured creditor. So it's a case of operational, because this particular case, this particular court has already decided in the case of Anand Sonbadra, who is the senior partner of AAA Insolvency versus GNIDA. And in that case, it has already been held that GNIDA or NOIDA, they are operational creditors when they give land on lease and there are lease premium or the lease rent is outstanding. In those circumstances, they are operational creditor. This judgment says that they are secured creditors. So that means GNIDA or NOIDA, we will come back to other agencies also. They are secured operational creditors. So this is a very like huge impact on the real estate in industries. No, like, see, we'll analyze it like all the kind of aspects of the judgment. The first is let us understand the facts of the case. A plot was allotted to the corporate debtor in Greater Noida by Greater Noida Industrial Development Authority, GNIDA. The plot was allotted on a lease premium, which was supposed to be paid in 8 years, and it was also having a 24 months moratorium. Now, the rights of GNIDA, in fact, they reserved the right to cancel the lease, resume the demised premises, subject to certain conditions. This is the rights that they have kept with them: one, to cancel and to resume the plot. Of course, the corporate debtor committed the default in payment of installments, and the corporate debtor was served with a demand notice and also a pre-cancellation notice, which is a demand notice pre-cancellation. Now, like after this, the CIRP started, corporate insolvency resolution process started in this case, and Noida Authority filed a claim of 43 crores being unpaid installments of lease premium. And however, that particular, the GNIDA claimed it as a financial creditor and also claimed a security interest on that claim. The RP said that it is not a financial creditor because of the Anand Sonbadra versus GNIDA. So it is an operational creditor claim, and you are supposed to file this in Form B instead of Form C. So that particular aspect was, then GNIDA did not file claim because the GNIDA filed the claim. The form used was incorrect according to RP, while the GNIDA filed a claim considering themselves as financial creditor. RP rejected the claim saying that you are operational creditor, but your form is incorrect. Thereafter, the GNIDA did not submit any claim as operational creditor because they wanted to challenge this observation of RP. However, they did not. However, they did not challenge the observations of the RP, but they did not file the claim as operational creditor. So see, the first application, in fact, GNIDA filed 2 applications before the adjudicating authority. One, it was challenging the RP's decision to treat the appellant as an operational creditor. And also, second application was that the RP, even if the RP considered them as an operational creditor, and based on their claim, they were supposed to be invited in the meetings of the meeting. However, the RP did not invite them in the meetings of the COC. Now, in this case, the NCLT dismissed the applications on the grounds of limitation, and the NCLT said that the GNIDA did not take any steps against the RP at that time for not deciding their claim. GNIDA was aware of the CIRP initiation. Now it is not possible for us to decide on this claim, and in the meantime, the resolution plan was also approved by NCLT. And since the resolution plan was approved, so therefore GNIDA application was rejected. 1, on the ground of limitation. 2, no steps were taken by the GNIDA when RP did not admit their claim. And 3, they were aware of CIRP. 4, that this application from GNIDA is not permissible now when the resolution plan has already been approved by adjudicating authority. GNIDA filed an appeal before NCLAT. Now the NCLAT says their contention that they are financial creditor, that has already been resolved. That has already been resolved in the case of Anand Sonbhadra versus GNIDA. And then the appellant would have charge on the property, and that would be under section 13A 14 of UP Industrial Area Development Act 1976. And this is what the pleadings, the GNIDA said that, so these are the 3 things, that they are financial creditors, and the GNIDA said before NCLAT that the resolution plan was passed in the absence of the appellant in the COC. Then their security interest under section 13A and 14 of UP Industrial Area Development Act has not been admitted. Therefore, the resolution plan is violative of section 30, subsection 2 of the code. However, NCLAT dismissed the appeal, treating the appellant as an operational creditor and rejecting the contentions of the appellant. That's what it was NCLAT said. Now, before the Honorable Supreme Court, let us understand what GNIDA pleaded. Now, the first GNIDA said that the GNIDA is a financial creditor having security interest on the assets of the CD. Then the entire land on which the project is conceived is owned by GNIDA. Even if the RP has considered them as operational creditor, they were not invited in the meetings of the COC, and the RP knew that we have filed a claim, and even if it was a wrong form, the RP should have admitted us. The plan which has been approved by the adjudicating authority has not considered their statutory charge on the basic subject matter of the real estate project, that is the land. The ownership of the statutory right, ownership of the land has actually been not considered, and it also impacts the feasibility and viability of the resolution plan, because in case GNIDA uses its statutory right, cancel the plot, resume the plot, and according to their section 14, they have the powers to take possession also through the local authorities, then this resolution plan actually will be considered as not feasible and not viable. That particular aspect has also been overlooked by the adjudicating authority and by the appellate authority. These are the pleadings before the Supreme Court. Now, let us see what the other parties. Like, who are the other parties? Like maybe RP, the resolution applicant, in whose favor the resolution plan has already been approved. So now they are saying that the one that they are operational creditor, this particular aspect has already been decided, and it is no longer res integra. So then the said uh, the like they are pressing their case as financial creditor. So based on the judgment of Anand Sonbhadra, it is not sustainable. So no relief should be granted. And also they said that the NCLT has no power to recall its order passed under Section 31, subsection 1, and therefore there is no remedy available now to GNIDA. And because of the inordinate delay, the resolution plan has already been approved. So therefore, it was pleaded. Then the Supreme Court, in fact, said that after hearing the parties, the issues were framed by the Honorable Supreme Court. Then the first issue was whether the NCLT has powers under Section 60, subsection 5 for recalling their order, whether the application for recall was barred by time, whether the resolution plan met the requirements under Section 30, subsection 2 and Regulation 37 and 38, and also, as claimed by GNIDA, whether the appellant, who is the owner of the land with a statutory charge over the assets, ought to have been given top priority or not. These are the decisions which actually deliberated in this judgment, having a lot of impact on the real estate industry and in some cases other industries also. Because this recall issue that we are going to discuss now, whether the adjudicating authority has power to recall its own orders, that is, the Honorable Supreme Court says, that is already given in Rule 11 of NCLT Rules 2016. In those rules, what is mentioned in the rules? Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the ends of justice or to prevent abuse of the process of the tribunal. Going forward, the Supreme Court also said that Section 151 of Code of Civil Procedure, 1908, it is saying the saving of inherent powers of the code. Now, what this Section 151 of the Code of Civil Procedure says, nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of court. Then court, in fact, went up to the various judgments of the issue already given by Honorable Supreme Court, like Madan Lal Chopra versus Rai Bahadur Rao Raja Seth Hiralal, like very old judgment of 1961. And then in all this scenario, then Section 60 was also analyzed by Honorable Supreme Court, which says that the powers under Section 60 one, basically the tribunal, because see, now since this Rule 11 of NCLT rules 2016, in that rules, it is applicable to the tribunal. Now, not the adjudicating authority, but yes, he said the tribunal has inherent power to recall an order to secure the ends of justice or to prevent the abuse of the process of the court. Then court says that it is not only the tribunal, even the IBC or Insolvency and Bankruptcy Code or any regulations framed thereunder in any way does not prohibit the power of this power of this particular court, this particular tribunal. So the power comes from the Rule 11 of the NCLT rules, and there is no provision under IBC or the regulation that this power cannot be used under the IBC cases. So therefore, as far as this recall is concerned, there are powers with the adjudicating authority to recall orders. Now, there are basic limited grounds are given by Honorable Supreme Court that the adjudicating authority will recall their orders only in case they find that, number one, that the order is without jurisdiction. Number two, that the party aggrieved with the order is not served with notice of proceedings in which the order under recall has been passed. Next, the order has been obtained by misrepresentation of facts or by playing fraud upon the court or the tribunal, resulting in gross failure of justice. Therefore, bench also said, the bench also said this is the power to recall is definitely available. So, Ankit, this is the first issue that we are seeing, and the whether the power to recall, whether it was time barred or not, but it was very clearly mentioned by the court that based on the facts that we could see, the particular uh, this particular case, it was not time barred. They have seen the dates, and the dates were within the time barred limit, and they also taken the they also have taken the benefit of that the judgment regarding the cognizance for extension of limitation that was because of the COVID, and that was the COVID time. There was an exemption given between 15th of March 2020 to 14th of March 2021, and this is something which was also used by the court to say that this was not barred by time. So, Ankit, at this moment, we actually have handled two issues. One, that the court has the power to recall, and second, that this was not time barred. The second was based on the facts, and also this power is actually very, very important. That once a resolution plan is approved, it can be recalled, but there are these parameters that we actually have to see. At this moment, Ankit, would you like to add something?
I think we are good. So we will move on to the other part of the order, and then maybe there are
Yes.
some
So
relevant
in case
questions that we...
then Ankit comes is the second part. The second part is in case a claim is submitted by the claimant, whether the form is appropriate or not, the RP's obligation is defined. The Honorable Supreme Court discussed while referring to Regulation 7 and Regulation 8 of CIRP regulation that there may be a situation where the claimant, in good faith, may place itself in a category to which it does not belong. He may consider himself as a secured creditor. He may consider himself as an employee. He may consider himself as an operational creditor. But then, according to the RP, the category that he actually has opted for himself is not correct because he has filed this claim in a good faith. So the only important part is that the claimant must file a claim along with the proofs of the claim. The proofs are more important rather than the form. Therefore, the Honorable Supreme Court reiterated that the duties of the RP and observed that the RP is under statutory obligation. RP is under statutory obligation to collate the data obtained from. So the data has been obtained from the claims made before it and also the information gathered from the records, including those maintained by the corporate debtor. Therefore, the data so collated forms part of the information memorandum, and accordingly, the resolution plans are submitted by the resolution applicants. Now, it says the which form is to be used, that is a directory regulation. It is not mandatory. What is the important part? That is the proofs of the claim that has to be submitted. So therefore, it is very clearly said that even if the claim is submitted by a creditor against the CD in a form which is not as specified in the CIRP regulations, the same has to be given due consideration by the IRP or the RP as the case may be. That is what has been held. Even if it's like, see, the only thing is that the RP must say that the proofs submitted are verifiable. And those are the admitted evidences that yes, there is a claim of this person. Now, if a person
So I have an opinion here. I think what is also important here is that okay, the wrong form is directory, but it is not mandatory. But at the same time, the contents of the form that are required from, let's say, a financial creditor, which are absent in the form for an operational creditor, Those are also queries that, the resolution professional can seek verification of, or, seek that data and say that since that data is not provided to us, we cannot verify the claim. Because there are differences in the forms, and what is requested in the forms matters. It is not just about Form C or Form D on the top. The contents are also different.
Now, if some of the contents are missing, I agree with you, then this can be asked from the claimant.
Yes.
But I think the RP cannot simply ignore a form which is come in a wrong form number. That is the basic understanding. If the evidences are submitted, uh, proofs are submitted, then it becomes the duty of the RP to work on that form and to try to admit it. And in case there is no response from the other side, then whatever decision the RP can take based on the claims and the evidences submitted, RP should take. That's what is the condition, I believe, the
Also, in case verification is pending, in case a form has been received, and in case certain claim has not been admitted by the RP because of pending information, I think it's like regulations are also now changed to make it clear that you make whatever you have part of the IM. I think that also secures the CRP case beyond, a normal system. So in this case also, in case there would have been a mention in the IM about the claim of of NOIDA authority in the wrong form, or whatever the case was, then it would have given protection to the resolution plan.
But in this case, one other pleadings have been used by the GNIDA, and that is that even if the RP was considering us as an operational creditor, the RP did not invite us to the meetings, because as an operational creditors also, because since we were more than 10%, we had a right to participate into the COC meetings. The RP did not allow our participation also, having full knowledge that there is a claim, and even if that claim is for 44 crores, and that claim is an operational creditor's claim.
Hmm.
So the para 33 of this particular judgment, I would like to read for everyone's understanding, which is important. In the light of the analysis of the provisions of the IBC and the regulations framed thereunder, in our view, though the commercial wisdom of COC in approving a resolution plan may not be justiciable in the exercise of the powers of the judicial review, the adjudicating authority can always take notice of any shortcomings in the resolution plan in terms of the parameters specified in subsection 2 of section 30 of the IBC, coupled with the regulation 37 and 38 of the CIRP regulations. If any such shortcoming appears in the resolution plan, it may send the resolution plan back to COC for resubmission after satisfying the parameters so laid down. Likewise, the appellant authority can also interfere upon noticing such any shortcomings in the resolution plan while exercising its power under section 32, read with section 61, subsection 3 of the IBC. Now, Ankit, with this paragraph, like everyone, although this is a final judgment from Supreme Court, but then of course we had many judgments where the NCLT and the appellate authority, they were using these powers, they were understanding these powers, they've got in section 61 subsection 3, because see, section 61 subsection 3 says an appeal against an order approving a resolution plan under section 31 may be filed on the following grounds, namely, it is covered in the code, Ankit. What are those grounds? One, the approved resolution plan is in contravention of the provisions of any law for the time being in force. Any law, it is not restricted to IBC, it is any law. Two, there has been a material irregularity in exercise of powers by the RP during the CIRP. Three, the debt owed to operational creditors of the corporate debtor have not been provided for in the resolution plan in the manner specified by the board in the regulations. The insolvency resolution process costs have not been provided for repayment in priority to all other debts. The resolution plan does not comply with any other criteria specified by the board. These are the 5 grounds on which the appeal can be filed before Honorable NCL 80 under section 61 subsection 3. Now, my understanding, Ankit, in such cases is one, that we have seen that there is a power, the adjudicating authority has also got a power. Then there is a power to appeal, like anyone can file an appeal who actually can observe that there are grounds which are listed in section 61 subsection 3, which is 1 to 5. This is the second, and also the Supreme Court says that it, yes, can be done. In case the resolution plan does not meet section 30 subsection 2 or 37 38, then the resolution plan, now how the Supreme Court finally decided that this resolution plan was not meeting the requirements of section 30 subsection 2 and regulation 37 38. The Honorable Supreme Court said that the resolution plan did not specifically place the appellant in the category of a secured creditor, even though by virtue of section 13 capital A of 1976 Act, which is the UP Industrial Development Act, in respect of the amount payable to it, a charge was created on the assets of the corporator. Non-placement of the appellant in the class of secured creditor did affect its interest. However, neither the NCLT nor NCLAT noticed this anomaly in the plan, which vitiates their order. So this is the these are the two things which actually made: one, that the representation was not made, and two, this resolution plan was their security interest was not seen. So this is an anomaly, and this actually vitiates the order passing the resolution plan, approving the resolution plan. Now, let us see what exactly section 13A of UP Industrial Area Development Act 1976 says. Now, it says any amount payable to the authority under section 13 shall constitute a charge over the property and may be recovered as arrears of land revenue or by attachment and sale of property in the manner provided under so many sections of Uttar Pradesh Municipal Corporation Act. So some powers have been taken by this UP Industrial Area Development Act from Uttar Pradesh Municipal Corporation Act. Therefore, this basically to recovery of the dues of the authority as applied to the recovery of tax dues to a municipal corporation. So that is section 13A, which actually talks about constitute a charge over the property and may be recovered as the arrears of land revenue by attachment or sale of the property. So these are the words which are very, very important. And also section 14 says that the forfeiture and breach of conditions of transfer in case of non-payment of consideration money or any installment thereof on account of transfer by the authority any site or building, or in case of breach of any condition of such transfer or breach of any rules or regulation made under this act, the CEO may resume the site or building so transferred and may further forfeit the whole or any part of the money, if any, paid in this respect. Also, the CEO orders of resumption of any site or building under subsection 1, the collector of that district may, on his requisition, cause possession thereof to be delivered to him and may for that purpose use or causes to be used such force as may be necessary. So when we see the powers which are given in section 31 capital A of UP Industrial Area Development Act, also taking some sections of Uttar Pradesh Municipal Corporation Act, it is very clear that it constitutes a charge over the property and also the rights of the rights of recovery as the arrears of land revenue, also the rights of attachment, and also the sale, and also the right of taking the possession back, and also the resumption of the plot. So all these powers which was there with the GNIDA, those powers, in fact, were not considered by the RP. This is what was held by the Honorable Supreme Court. And therefore, the other which is important, Ankit, so other part which is the resolution plan, and which says is the use of land. The Honorable Court says that in this resolution plan, the same land on which there is a charge, power to cancel, power to resume, power to attach, power to sell is available with GNIDA, that land has been envisaged as the land which is part of the project. And the Honorable Supreme Court says that this land is not owned by the corporate debtor. So in this case, the resolution plan is conceiving that this land will be used and the construction will be completed. And the land actually belongs to Greater Noida Authority, which is a statutory body. They have their own rules and regulations. They have their own attachment. And that was required to be examined. The Honorable Court said that that was required to be examined to understand whether the resolution plan is feasible and viable. Because the Honorable Court says that this is the duty of the Committee of Creditors before voting a particular resolution plan, that the resolution plan must be feasible and viable. So if there is a technical difficulty that this resolution plan cannot be implemented in such manner, that means that the resolution plan was not feasible and viable. So that is also an error by the Committee of Creditors. In these circumstances, the resolution plan envisaging necessary approvals. Now, there are various statutory authorities granting various kind of approvals for a particular project. Maybe for a real estate project in Mumbai, there are about, because I am conducting a process there, there are about 18 authorities who are giving me one or the other kind of permissions or approvals or the licenses or go-aheads. It may be Slum Rehabilitation Authority, it may be Mahada, it may be the pollution, it may be the environmental clearance, it may be the airport authority. So there are many. So all these authorities' approvals are also envisaged in the resolution plan. It is very clear that the resolution plan says that all these approvals will be taken. So the approvals, how the approvals will come also has to be examined by the Committee of Creditors. If the approvals will not come, that means the project is not feasible and viable. So therefore, the feasibility and viability has to be seen. If the feasibility and viability is not seen by the Committee of Creditors, that is also an error. And therefore, the resolution plan approval order can be recalled. So in this case, finally, the Honorable Supreme Court said that the GNIDA was not served with the notice of meeting. 2, all the proceedings up to the stage of approval of the resolution plans were ex parte to the appellant. The appellant was not party to this. 3, the GNIDA submitted claim and was a secured creditor by operations of law, yet the resolution plan projected the appellant as one who did not submit its claim. 4, the resolution plan did not meet all the requirements under Section 30, subsection 2 and Regulation 3738. So therefore, what finally the Honorable Supreme Court said, the resolution plan shall be sent back to COC for resubmission after satisfying the parameters set out by the code as exposed above. So all these things, they are code creditors, they were not given notices. All these resolution plan must satisfy all these parameters. This was the final order from the Honorable Supreme Court. So in case we kind of reiterate, what are the takeaways from this judgment? 1, that the claims submitted during the course of CIRP cannot solely be rejected based on the incorrect form. Number 2, the form numbers are directory and they are not mandatory. What is mandatory is the proof of claims, the evidences of the claims. Once the claim is submitted, it becomes the statutory duty of the RP to maintain a list of creditors and to verify that and to acknowledge the claim. Now, the operational creditors with significant dues should be served a notice of the COC meetings, which was overlooked in this case. However, like this, even in this case, operational creditors with significant dues also should be considered as that there may be many people who have significant operational creditors claim. So they should also be invited in the meetings to avoid any litigation. And where a charge is created, the resolution applicant should be, the NOIDA should have been treated as secured creditor, which was not properly addressed, and the resolution plan therefore failed to meet necessary parameters. Therefore, it has to went back. It has to go back. So this is the entire crisp of the judgment. Now, in fact, we are also trying to say, let us understand the impact of this case on various real estate cases under IBC. The first category, Ankit, I have taken is the resolution plans approved by the Committee of Creditors and Adjudicating Authority, but pending implementation. Now, in this case, what will happen? There may be various claimants and various statutory authorities or landowning bodies having special statute or statutory charge on the land. They may approach the court for recall of the order. They may approach the court for recall of the order which they have passed under Section 31, subsection 1, that is the approval of the resolution plan. They may use this Rule 11 of the NCLT rules or Section 151 of the Code of Civil Procedure. Now, the various authorities having charge on the project or the land, they will actually also affect the feasibility and viability of the resolution plan. Like in our experience, we have seen there are various claims from town and country planning departments of the states, like external development charges, internal development charges, license fee. Then there are claims from the city development authorities in various states, like in Delhi, we have Delhi Development Authorities, in Nagpur, we have Nagpur Development Authorities. So then we have these city municipal corporations. They also have some kind of claims and they also have the rights of such kind of statutory rights on the property. Then we have also RERA. The RERA also have been levying penalties on the projects, and the RERA recovery mechanism also have to be seen whether they have any charge to recover their penalties. Then we also have state industrial development corporations like PSIIDC, HSIIDC, or West Bengal Industrial Development Corporation. Then there are state urban development authorities like HUDA, Mahada. These are all various authorities. In case we go into their detailed laws and regulations, they also, all of them have powers to recover their dues as areas of land revenue, and they also take powers from various laws that they have made for their own state. Also the Slum Rehabilitation Authority. So these are various authorities, and in case we do not include their claim into the process, in case we do not consider their statutory right, then of course the resolution plans, whatever we approve, that may finally be recalled. So we somehow this particular judgment, the time barring was based on the facts. So in many cases, it may not be within the permitted time for filing an appeal. So that may be a saving pleadings. But otherwise, whenever we talk about the real estate cases, we need to understand all those regulatory authorities who are supposed to give various permissions, who are supposed to give various renewals. In case we are not considering them as part of the resolution process, then it will be difficult to see whether it will be difficult to say that the plan is feasible or viable. Then, Ankit, the resolution plans which are approved by the COC and the pending before the adjudicating authority, then all these authorities, all these claimants will take they will invoke the Rule 11 and Section 151, and they will also say that these objectionable, because see, in this case, they will, because this resolution plan has not been approved, but simply they will invoke this judgment and they will file their applications regarding the cancellation of land or resumption of plot. So this is something which is very, very important. So Ankit, I think we can take up the various questions. I believe a very important part of this this is that it is impacting cases other than real estate also. Because whenever there is a factory which is on a land given by State Industrial Development Corporation and there are some dues against that land, that also will have to be considered as secured creditor. So there are various lands which are leasehold lands, and the factories have been set up on that. Various penalties are imposed and various delays, interests are there, and the lease rents are not payable. All those claims should be taken by all the RPs, and they should be considered as secured creditors, secured operational creditors. And in case the claim is very huge, then they should also be invited in the meetings of committee of creditors. So in most of the cases in North India, where NOIDA, Greater NOIDA authorities, or all these authorities presently are struggling, so they have got some relief, and they are at least now been considered as secured creditor. In most of the cases, either the resolution plans approved would be recalled, or the resolution plans which are pending before the adjudicating authority would be sent back to COC for doing that readjustment after considering them secured creditor. So this is the days. I think let us take the questions, and in case somebody would like to speak also, that we can take.
So I'm starting with the questions, and let me start with the order of the questions that first came in. So if the FC wasn't holding the security interest, will the classification be as per Anand Sonbhadra order for this order? I think if there is no security interest, the Anand Sonbhadra order from the Supreme Court simply said that the classification will be operational creditor because of the nature of lease of the land given by NOIDA. So
Yes, right.
if there is no security interest from a similar because of course Greater NOIDA has the statutory authority, so that will remain. Similar authority should also be available under other acts that state governments make. But
So
if there are
let me take up. In Anand Sonbhadra case, we use the accounting standards, and we classified the lease as a financial lease as well as an operational lease. So when we saw the entire agreement of Greater Noida Authority with the corporate debtor, and it was pleaded before Honorable Supreme Court that the entire agreement is operational. It is not financial. So therefore, it was only on one issue, whether they are operational or they are financial. So they are operational, so they are not participating into the COC meeting. However, they are invitees to the COC meeting in case their claim is substantial. But in that particular issue, the security interest was not at all discussed.
right. Then we have the next question from Ranjan Ji. Ranjan Ji is asking whether order of Honorable NCLT can be applied for recall within 3 years of getting the order copy.
I think no, because in this particular case, the Honorable Supreme Court has, based on the facts of the case, have said that they based the information that was received by GNIDA, and the appeal was filed within that information, because the GNIDA in fact pleaded that they got this information from the monitoring committee, and the date on which the monitoring committee gave them the information, and within that time the appeal was filed. And in the second appeal, the Supreme Court gave them that exemption between 15th March 20 to 15th March 21. This was the exemption given to in this case.
CA PRABHJIT is asking if forms are not specified, then can unstructured forms be accepted? Based on the current understanding, I don't think there is any scenario when forms are not specified. Forms are always specified, and so are the details that are required to be filled in those forms. So any other claims also have a form. So I don't think that scenario comes up that there is no form specified in any of these circumstances.
The forms are required, but the forms are directory, not mandatory. The RP is getting the evidences along with the form. Those evidences can be considered, and RP should consider some. And in case RP still feels that it is to be rejected, then the rejection order has to be passed. That rejection communication should go.
Then Anil Kichaji is asking whether the titles of land held exclusively by the landowners under JDA without any security given to any bankers, lenders, is also a security interest, making the landowners a secured creditor. Also, with the landowner's consent is must on any plan, else the plan is not feasible and viable. I think the security that the Honorable at the Apex Court has talked about is coming from that act. In absence of any such security which is available with the landowner, I don't think the landowners can say that they are secured in any nature, because the
But Ankit,
this
there is a
this
second issue. There is a second issue, that is the feasibility and viability.
hmm,
If the land is envisaged in the resolution plan as the asset which on which the project would be completed, if the land is also conceived as will be used for the resolution plan, and in most of these joint development agreements, I have seen in most of these agreements there will be a cancellation clause, and that cancellation clause will be very strong with the landowners. In
hmm.
case their terms and conditions are not complied with, they definitely have the right to cancel the joint development agreement. They also have the right to take away the possession of the land back from the builder. So when there is a clauses like this in the joint development agreement, I still believe the feasibility and viability will definitely become questionable. And I will not say that it is a right, it is a security interest, but the feasibility and viability, and this, therefore the resolution plan cannot be approved because of the feasibility and viability. And the committee of creditors definitely will have the, sorry, adjudicating authority will have powers to send it back to the COC to consider the feasibility and viability. And
So
this is
I
happening.
have an opinion here, and that opinion is that when we do valuation for such assets, and we compute a value for the project, after taking into consideration the various liabilities of the project, the construction cost, and we simply do use what is called a residual method, which is prescribed under IVS 410, where you say that, okay, this is the value that you will get from the sale of the assets or sale of the flats. This is what is the cost of construction. This is maybe the developer profit, and you come to a value. Now, if that is the value of the land which is available to the creditors, then if that a portion of that value is offered to the landowner or other agencies which are party to the entire system, then you can easily say that you're offering a requisite value to the secured or the landowners also. I think that's a way out to ensure that you're giving something to them, and ensuring feasibility. And in case the value is negative, then you can justify that there is no value of the land per se because of the various rights that have already been created on the same.
See,
So
when the
that's to have been.
adjudicating authority is telling us again and again, go and resolve with Noida or Greater Noida authorities, so that actually means that they are not finding the plan as feasible and viable, and they are asking us to make it feasible and viable
No, we are
rather than
talking.
rejecting it.
I understand that with those authorities, it is there, because unless and until those authorities are, accepting your plan, or rather saying that this is okay or this is legal, there is no way out. You need their permission at every stage. But when it is about a landowner which is unsecured, which is a private landowner, there may be those limitations with respect to feasibility are absent.
Now, if the landowners are not paid, but see, most of these agreements are, Ankit, like this, that I'm contributing land and you are the builder. Now, the builder will complete the project, and maybe 40%, 50% of the constructed space actually will be handed over to the landowners. Now, in this particular case, if the 50% of the assets are supposed to go to the landowners, or 40% of the total space was supposed to go to the landowners, and can any resolution plan be implemented where the landowners would be given nothing? Because they have agreement, and they definitely will go to any kind of court that our rights are not protected, and we have given the land, and it cannot be, we can't just get out of the process. So they have a right of rejection. So they will reject, they will cancel the, terminate the agreement. So
I'm
they
not saying that they will get nothing. I'm saying they should get whatever is commensurate with the values that are computed with respect to
absolutely,
that land. So that
absolutely,
will be what will be
absolutely.
taking care of that work.
Yes, yes.
Uh, then we talk about the aspects of viability and feasibility of plan are being mentioned in the resolution plan. Okay, I don't. Then we have green clearance. I think all that is something that is understood that it will be required, whether RP has to charge the ROC charge is something that operational creditors were secured by operation of law. I don't think the ROC charge is. I think the
See, the
order is very
definition of
clear.
security interest, which is given in the regulations, that definition says the ROC charge or IU charge or SIRSAI charge but that is something which is not exclusive. That definition is inclusive. Any other evidence can also prove security charge other than these three items. If there is an agreement with the bank that this particular property was mortgaged, however, if there is a failure to create an ROC charge or IU charge or SIRSEI charge, I believe under insolvency, based on those documents, based on the loan taken, it will be considered as secured.
Understood. So then VAT department, without considering VAT as a secured creditor, the resolution plan was approved. Now, I think we're talking again going to rainbow paper. I think we have talked about that, and there are other judgments that have kind of changed that process as to what are the rights of government departments with respect to a resolution plan. I think whether they will be considered secured or not, I think that has already
You
been
see,
taken care
Ankit,
of.
we have to differentiate the tax dues where the government has taken a decision,
Hmm.
which is the dues which actually would be given to the Consolidated Fund of India or the Consolidated Fund of a state or any local authority. So these are the
Yeah.
taxes.
So
These
there
are
we
the
need to follow the Raman Ispat judgment,
yeah,
right? Now
the
that
taxes.
that has clarified that.
Yeah.
Yeah.
No, no. The Raman Ispat judgment, of course, later on, we actually have to see which will go to the larger bench.
Hmm.
So what I'm trying to say is that the rainbow and this are slightly different.
Hmm.
Rainbow is talking about the tax dues. This is talking about the statutory charge against the dues of a particular statutory authority. These are two different things.
So Mr. YK Gupta and Pradeep ji are asking that, what if even if they're considered as secured OCs, how will it impact the COC decision? So the answer is very simple, that if you compute a value for a land, let's say, and that land is a security with the OC, then you take care of the interest of that OC coming in from that secured asset. That is how it will impact the COC decision. Without the COC taking care of that value going to the secured OC, which is due to him as per the value of the assets, the resolution plan then of course becomes unfeasible, because you're not giving that value to the OC or taking away something that is a secured asset with them.
So
How
Ankit,
will this
I will add here.
hmm,
Ankit, I will add here. Now, Section 30, subsection 2, it says that the operational creditors would be offered at least the liquidation value. Now, in case the company goes into liquidation, what would be distributable to the operational creditor? That should be given. That must be given to them in a resolution plan. This is what Section 30, subsection 2 says. Now, in case the operational creditor is a secured creditor, then we have to make it pari passu with the other secured creditors. In the case of real estate, the home buyers are unsecured financial creditors, and the other, in case the this secured creditor, the statutory charge holders will become the secured creditor, then they will get pari passu with the other secured creditors. So that is the minimum amount which will be payable to a secured operational creditor. And in case not paid, then Section 30, subsection 2 is not complied with.
understood? So Mr. Sapan is asking that if the wording resolution plan is sent back to COC, means CRP is reinitiated and RP will again have control of the company. So it means that the resolution plan will be considered afresh by the COC, maybe with or without changes, after taking care of the interest of the Greater Noida Authority in this case. Then
I think question is important. Like maybe after 2 years, this judgment has come. The implementation have already started. RP is nowhere in the picture now. Only the monitoring committee may be there. Now, what will happen? How the COC will consider? When the COC will be there, then the RP will definitely conduct the COC meeting. There is no process that the COC meeting, the COC members will get together and pass a resolution. So the RP will again get activated based on this judgment. The COC will also again get activated based on this judgment, and a resolution will be passed after considering that debt as a secured creditor. In case the resolution is not approved, then the company will go for liquidation. So definitely the RP will reactivate itself. COC will be reactivated.
right. So a case from Mr. Maheshwari. Lalit Maheshwari says RICO has cancelled land given to CD before initiation of CRP, but CD has taken loan on that land for construction of hotel project, which was not completed due to some environmental issues, and RICO cancelled land. Afterwards, CRP has initiated after cancellation of land. RICO saying that land does not belong to the CD. Think that if the
We have, Ankit,
cancellation.
various cases like this. With various states, we have such cases. We have such cases with West Bengal Industrial Development Corporation, Chhattisgarh Industrial Development Corporation, Haryana HSIDC. So all these, in various cases, the cancellation has been shown as before the commencement of CIRP.
Hmm.
Now, in this particular case, when the resolution plan is being approved and that land is also being part of the resolution process, then in this case, it is very difficult to get a resolution plan approved because the dues of the Industrial Development Corporation of that state are not, even in most of the cases, they are not filing their claims. Once the land is cancelled in their records, they are not filing their claims. So we have like tried various remedies for this, but then finally we have found that we should go to the High Court of that state and say that this cancellation is incorrect, and now the company is under CIRP. The banks have given loan against this land. The banks have also taken the mortgage permission from the corporation. So therefore, it is the kind of the scenario would be that
Situation
now
is illegal, and rather they
it is
should file a
illegal.
claim.
So they should be this particular cancellation should be considered as invalid, and they should file their claims. And also a commitment can be made to the Honorable High Court that because of this judgment, now we will consider their claim as secured. I think that is the only remedy.
Right. There were a few raised hands, but because we had taken several questions, I can request those participants who want to, maybe mention their question to raise their hands again. One of the participants, I believe, they have, raised their hand. So I will request you to be short and limited to the question, please, so that we can finish in time. Yes, Sandeep ji.
Sir, I just want to have a small query that can a resolution plan stipulate that money is to be recovered from the owners of the delivered flat which are unregistered to whom no dues have been issued and even without their express approval? Because tomorrow they may say that they are not interested to participate in it and that entire resolution plan will go down. Or can they be forced to contribute?
So one, that you are saying that they have been given no dues by
Yeah.
the
No dues
corporation.
And
certificate, they
delivery
also have the
also.
possession. They
And
They
also have
have
the
delivery
they
possession.
have been
also.
given no dues and they have been given possession also.
Yeah.
Now the
But
Supreme
delivery is
Court
not
says,
done.
now the IBBI say that anyone who has been given the possession, their unit will not be considered as part of the liquidation estate. So
Perfect.
then
This is a
why are they filing
clarification
their
part of the
claims?
latest.
No, why are they filing their claims then?
Should sure, because their flat is not yet registered, and even the RP is registering their claim only at rupee 1 because nothing is to be paid to them technically.
Okay.
But
It is
registration
only
is an
the
activity which is not yet done.
no, I don't think then in case any person has actually been given no dues letter by the corporate debtor, but the no dues given by the corporate debtor has to be based on the facts, because
It is based on facts. All amount have been paid. All receipts are there.
no, I think like I have seen various cases where the money has been given in cash and the corporate debtor has actually given the no dues. Second, there are many cases where the delayed compensation has been given exorbitantly by the corporate debtor to some of the unit holders and no dues have been given. So all these are assumptions. However, if there is a genuine case who has a builder buyer agreement for 40 lakhs and he has paid 40 lakhs, then the no dues has been given. I don't think any resolution plan can recover anything from that person.
So such resolution plan will not see the light of the day at the time, even if the CO, because in the case I'm talking about, the COC, the case itself is such where it has been initiated by a friend of the corporate debtors owners, directors, and a small amount case, so that
I
original
think, I
debtors are
think, I
getting
think,
relieved and they want to
Sandeepji,
collect money and
overall,
do something.
Sandeepji, overall, this is what we understand in this matter. I think we have shared what we think, and I think we can always look into specific details later offline.
Okay, fine, fine.
I have Mr. CA Prabhat Jain ji.
Thanks a lot.
Maybe he can unmute and say what he wants to say.
Thank you, sir. Sid, we have received the delayed claim from the financial creditor,
Mhm.
and he has never reached to the NCLT. Now we should accept his claim because of delay and form, etc.
I think the IBBA has given the new rules, and that is
Until 90 days, you have to accept the claim. After 90 days, you have to verify the claim and place all the claims that you have received post 90 days. You have to file an application to the NCLT with the details of those claims for them to approve them or disapprove them.
Yes, sir. Even after that, after expiry of 180 days, we received the claim.
Now, let me again say, the IBBI has issued the regulation which says that a week before the before the issue of RFRP, all the claims, whatever is received by the RP will present before the COC a week before the resolution plan is put to vote. So therefore, RP's duty is to all the claims, whatever is received before the issue of the last RFRP, that has to be listed on a document along with the RP's comments, and it has to be presented before the COC. And then RP will file a condonation application to adjudicating authority along with the RP's observation and along with the COC's observation. So therefore, now there is no question of belated claims. So in case there is any claim which has been received after these dates, then the RP has no power to admit, then that person will go to NCL. I think this is very clear.
Sir, it was the practice we are following. Now the confusion was coming from this recent judgment we were discussing about the Greater Noida and his submission.
This judgment is not about belated claims. This judgment is the inappropriate forms.
Correct, sir. Okay, thank you.
Yeah.
We have another raised hand, so yes, please. I think I only see the email ID c.engineer31. If you can unmute and share your question, else then we will we are done with all the questions, else we will wind up. So thank you everyone, and this was indeed a very a topic which had a lot of interest and a lot of takeaways from this judgment, and looking forward to see you in the next webinar.
Thank you very much. Thank you. This is our way of learning. Thanks.
Thank you.